Well, good evening and welcome everyone to the University of Manitoba's Tuesdays with TD webinar, Estate Planning 101. I'm Tracy Bowman. I'm the Executive Director of Alumni Relations and a very proud University of Manitoba alum. Before we begin, I would like to acknowledge that the University of Manitoba campuses and research spaces are located on the original lands of the Anishinaabe, the Aninawak, the Unisawak, the Dakota Oyate, the Dene, and the Inuit, and on the national homeland of the Red River Métis. recognizes that the treaties signed on these lands are a lifelong enduring relationship and are dedicated to upholding their spirit and intent. We acknowledge the harms and mistakes of the past and the present. With this understanding, we commit to supporting Indigenous excellence through active reconciliation, meaningful change, and the creation of an environment where everyone can thrive. Our collaboration with Indigenous communities is grounded in respect and reciprocity, and this guides how we move forward as an institution. So tonight, we are discussing all things on estate planning. Why do you need a will and a power of attorney? Who should you appoint to these positions? And what happens if you don't have these documents? So these are just a few of the questions that we will be addressing when understanding how to establish your will and power of attorney. And we'll also discuss key considerations for estate transfers and leaving a legacy, along with probate, tax considerations, and the estate settlement process. So that's quite a big agenda for the next hour. So I'd like to introduce our speakers. They are Daneeka Rico, who is a senior financial planner with TD Wealth, and she's been working the financial services field for over 17 years. And Kendra Dion, who is an estate lawyer who's been supporting both Manitoba and Ontario clients. So welcome, Daneeka and Kendra. And I should also mention that I'm going to be presenting just for a few minutes at the end on behalf of the University of Manitoba's gift planning team, just to talk about leaving a legacy at the University of Manitoba, if that is at all of interest in any of your estate planning. So the last thing I wanted to share before I do turn it over to our speakers is I would be remiss if I didn't properly thank TD Insurance, a University of Manitoba affinity partner, for their sponsorship and their leadership in today's financial webinar. As you may know, TD Insurance provides discounted vehicle, home, and travel insurance to alumni, students, staff, and faculty, as well as direct investing opportunities through TD Wealth, and very soon, a small business insurance product as well. For those of you who are entrepreneurs, both budding, long-term, or those who maybe you know of others who are entrepreneurs. And so you can look at all of these opportunities with TD Insurance, as well as other benefits that we offer to you as alumni on our website at umanitoba.ca/alumni for more information on perks and benefits. So now with that, I'd like to turn it over to Kendra and to Daneeka to share about Estate Planning 101.
Awesome. Thanks, Tracy. And thanks so much for having us tonight. Originally in the presentation, both Kendra and I had a little plug on a bit about ourselves, but Tracy, you did a really nice introduction, so I'm going to leave that there. This is a topic that I can probably speak for Kendra in acknowledging that it's a pretty big one for us. This is her bread and butter for her job, and it is a big component of the conversations that I have with my clients. And so there are so many facets to an estate plan that we don't even think about. A lot of the time when you are asked about an estate planning strategy, we think about a will, a power of attorney, maybe a healthcare directive, and that's as far as it goes. We don't think about the years prior to passing and then the implications of the decisions we make post-passing. And so I recognize that we've got an hour, and both Kendra and I are pretty passionate on this topic. So we're going to try very hard to keep ourselves on point and make sure that we're moving along in a reasonable, appropriate way, because we do want 20 minutes at the end available for you guys to ask questions, because that's generally where the biggest value comes in. If you have a question, there's somebody else who probably wants that answer as well. And so we want to make sure that we have time for that. But in the spirit of moving along, let's talk a little bit about estate planning. And so when we talk about estate planning, it goes beyond, like I said, wills, powers of attorney. It's about making sure that we have an appropriate wealth transfer strategy. And that can sometimes happen even 10 years pre-passing. Sometimes it's even longer than that. The idea is to make sure that we understand what matters most to you, what your priorities are, and ensuring that the way that we leave a legacy acknowledges those things that matter most. When we don't have these things in place, we can leave our families and our loved ones with a lot of a mess, per se, and we don't want to do that. And so today is really about helping set that up for success and what that looks like over time. And so why does it matter? If we don't do this, the reality is that there is that emotional burden that we leave for our family. It can also be legal complexities as a result of not leaving funds in the way that we intended. And so Kendra will talk a bit about unintended distributions of assets when we pass away intestate, or when we pass away without a will, is ultimately what that means. Money is going to be sent over to our families based on a legal line of procession, and leaves no room for us to dictate how that money is going to flow through. As a result of being passing away this way, we can create increased costs. We can create increased tax burdens, both to you and your beneficiaries, and we leave a state where there is no peace of mind. And so again, we want to make sure that we've got those things set up in an appropriate way. And I acknowledge that when we talk about estate planning, and we were talking about this before we jumped on and opened up, this is a pretty big, deep conversation. And a lot of us get uncomfortable with this conversation about passing away and how we're going to leave our money. And when I think about these conversations with my clients, I bring it up every single time we start talking about our financial plan, because it matters. And I want to make sure that I'm setting you and your family up for the right way. But what I forget to acknowledge is that I have this conversation every day, and you may have this conversation once in your lifetime, or maybe once a year. And the reality is it coming to terms with our own mortality can be a difficult one. And so a lot of the time we don't have these conversations because we don't want to put ourselves in that mindset and think about, well, what happens if I'm not here? And what happens to my family? And what happens to my money? But more importantly, that means that I'm not present anymore, and that hurts. And so when we can step aside and put away our emotions for a moment and really think about this from a tactical, analytical perspective, we can make sure that we don't leave any doubts in the way. And so let's talk about some key components, because that's really important. And Kendra, I'm going to ask you the question because you and I have different definitions. When you think about an estate plan, what does that mean to you?
So it can really encompass a lot of different things. Before we get into the heavy facing your mortality, part of that estate plan could be a succession plan for a business. I know Tracy mentioned, if there's any young entrepreneurs here, there could be plans for retirement so that you're passing the torch. Those are the fun ones because you get to move on and do something afterwards. But then there's also the aspect as well of your will, which is what happens when you die, your power of attorney, what happens if you're incapacitated, healthcare decisions, and then a whole host of financial products that you can use to create that estate plan and make sure that your loved ones are looked after, or your business as well. So it really is a giant circle of tools that interact with each other and work together.
Yeah, and I think that's something that's important for you to understand, is that an estate plan is not just connecting with a lawyer. It's connecting with a lawyer, it's connecting with your financial planner, it's connecting with your accountant, it's connecting with your business if you own a business, connecting with your partners, connecting with your spouse, and having open conversations about how you want things to happen. The more dialogue we have, the more prepared we can be. When I think about the importance of planning, a lot of this comes around, thoughts around pre-gifting. And one conversation that comes up regularly, in fact, I was on a call with one of my clients earlier today, and the conversation was around, well, like, Daneeka, I don't need to take money out of my RSP right now, but like, should I be taking money out of my RSP right now and, paying the taxes and moving that to my tax-free savings account and allowing it to grow over time versus having a potential tax burden should I pass away, let's say tomorrow, and have all of this money hit onto my final tax bill? What is the right strategy? Or a further conversation that happened recently with another client was around pre-gifting. And so one of my clients had ultimately said, Daneeka, I want to leave $100,000. I actually want to gift my daughter $100,000 now. I want her to use it while I'm alive and I can see the benefits of it versus her getting it when I'm 90 and I'm dead. And for that conversation, it comes down to, well, it depends. Does it make sense to pre-gift? In her circumstance, after we looked at our entire financial plan, both her needs in retirement and her legacy strategy, it would leave her lean. So if we gifted money today, not only would we have a tax implication that we didn't want to have, but in addition to that, if something happened when she was 80 and we had increased healthcare costs, we didn't have access to that money anymore because we already gave it away. And so we could have a risk for her living a little bit longer. On the flip side, I had a client about a week ago where I sat down with them, and she's 80 years old and has a very sizable portfolio. And in her situation, she's receiving so much interest income on an annual basis that it's actually clawing back her old age security. And we're taking nominal payments out of her investments on an annual basis. And so for her, she wanted this money to go to her children. Well, by us pre-gifting and giving money today, not only were we able to allow her to see that money in action, but we were actually able to reduce her tax burden year over year, to reduce her old age security callbacks. And so in that circumstance, it made sense. But if we don't go through this conversation and we don't understand what matters most to you, we can't actually understand what is the right strategy and how do we set that up in the right way going forward. All right. Now there are some pitfalls when it comes to estate planning. And this is where, a lot of my clients who don't estate plan, because that happens, and they say, Daneeka, my family can deal with it when I'm dead. I'm not here. I don't care. You said intestate laws, it goes to who? It's fine by me. I don't care. Let's move it on over. So, but there's some problems here, and there's some things that we really need to dig into. So, Kendra, can you share a little bit about some of the common estate planning issues that come up when we don't have an appropriate plan in place?
Yeah, so first off, actually, I was meeting with a young couple this morning who have young kids, and most of my work is with seniors, so I enjoy when I'm working with the younger couples because they're more complex. We have more things that we got to think about. First off, being underage children. If you leave money to anyone who is under the age of 18, they can't receive that. And if you don't create a vessel for that to happen, then the public guardian and trustee, i.e., the government, is managing your kids' money. So we need to talk about guardianship for them as well as who will manage the money and realistically what will happen with that. So in Manitoba, you can't officially appoint that guardian in the will. You have to go through an application process, but I always put wishes. Why have you chosen this person? Why do you want the court to appoint that person? And oftentimes it's they have a relationship, they will maintain stability. And then the second piece is the things. Because if you have a 2 or a 3-year-old and you leave them the house in trust without any plan as to what happens, the trustee managing that trust might not be able to sell it if it's necessary. So we had to think about, okay, can they sell the house if they need to? What about the car? If they're old enough, can they have that? And we talk about all of those things. And then we think about, okay, are we being fair? This often happens too when I'm dealing with my senior clients who have adult children, one who's launched and one who hasn't. Do you want to distribute things unequally intentionally? And if so, you really need to talk to your family. Like Daneeka was saying, oftentimes it's very uncomfortable to talk about these things. But one of the things they taught us in one of our courses was a situation where mom wanted to leave the house and the big assets to the one who didn't have funds, and but also didn't want to treat the other child unfairly. By asking a simple question, his response was, I don't care about the money. I just want dad's old stamp collection. And that's what mattered to him. So we look at that, and not only about fairness between the family members or whoever you're leaving things to, but also if you intend it to go one way, will those tax implications and different things actually even out? So if you have a house and an investment fund, sometimes people will say leave the house to A, leave the fund to B. It may not quite work out that way. And then there's other complexities you need to think of. The biggest one being dealing with someone who is receiving any form of social assistance, disability, any of those benefits are tied to income. And if they receive certain assets, that will kick them out of that program. A good example that I always share when I'm talking about myself, I came to this job because I was in an accident in my 20s. I had to think about, gee, in my 20s, what if I didn't wake up? And while I was on disability benefits, if I earned $5,000, I would lose all of those benefits. So we want to protect those, especially those who are disabled long term. We create what's called a Henson Trust to protect them, where the assets never vest in them, and thus they never lose their benefits. And then, of course, there's the tax and the financial stuff, which, just like Daneeka said, we bring in all kinds of different specialists to touch each part of that estate plan. And while I have the basic tax advice, I always turn it over to either my accountants or financial planners. So I'll let Daneeka take the lead on that.
Yeah, a couple of examples I wanted to acknowledge, Kendra, when you were bringing that up. A really clear example recently was a client of mine that I've had for several years, and he was in his late 60s at the time when I started working with him. And one of the conversations was around setting up a will. And he owned his own corporation. So there was a business. The son was actively involved in the business, was really the key stakeholder beyond himself, but he had no shareholders agreements acknowledging who the business went to or if the son even had a vested interest in it. He didn't set up a will. And so every year he would come in to see me. And every year I was like, hey, bud, like, where are we at? Did you get that will in place? What are you doing with your business? And every year he's like, I really want it to go to my son. Well, he passed away, unfortunately, this year, and he did not have a will. And his son was convinced that this business was going to go to him. He was the active party. He was the one who ran the show. He deposited the checks. He made the payments. He had the relationships. But because of intestate laws, it went to his wife.
Yep.
And his wife was not operating the business. And so there was a very big discrepancy between the son saying, I thought this asset was coming to me. I thought that this, all of the vehicles that were inside the corporation were coming to me. And it turns out they're not. And how do I deal with this? And ultimately my interest is in the estate and has to be making sure that I'm preserving that for the wife at that time. And so all conversations need to go through the mom, and that was a really difficult conversation. And so it is not in your best interest to leave it to intestate laws. It is in your best interest to make sure you're having these conversations with your family and making sure that everybody is on side and agrees with what we're doing. In recent years, family meetings or family conferences has become a thing where we, encourage people to sit down with your loved ones and have these conversations so that and they know, and there's no surprises, right? Another key example, and you brought this up on the Henson Trust, and I'm dealing with this right now, where the mother passed away, and luckily she did have a will, and she placed everything into trust. And the daughter, who is on disability, wants some of that money flowing to her, and rightfully so, to cover expenses. But for her rent assist, it isn't just income tested, it's asset tested. So the more
Yes.
money that we put into her personal name, the less she's going to have support. And so getting that across and saying, we actually need to keep this in the trust and then discretionarily pay this out when you need the money versus leaving it in your bank account is really important so that you don't have any surprises.
Oh,
Right?
definitely. I was actually going to say I'm dealing with that right now with a relative. I'm going to be in charge of her Henson Trust and she wants to stay in the house. And I'm having to break it to her the same exact thing and making sure that she doesn't lose that protection over everything. It's very
Yeah.
complicated. Yeah.
Yeah. When we think about it from a tax perspective, so, you may know, but if you have a spouse, and I'm going to speak particularly to registered investments right now, and then I'm going to talk a little bit about your family cottage, because that's important too. And it's a really big contention that we don't think about. But if you have a spouse and you pass away, all of your assets can flow to them and relatively tax deferred. Your non-registered investments, we can tax defer your capital gains if we see fit. Your RSPs can slide over. If you've got a successor on your TFSA, which is different than a beneficiary, and if anybody wants to ask about that, ask in the questions at the end and I'll talk about it, because there is a difference from a tax perspective. But we can flow things over to the spouse. But when the second spouse passes away, this is where things get ugly. And so, if we have not planned appropriately and you were a very diligent saver throughout your life, let's say, for example, you built $500,000 in your RSPs or your retirement income funds, and we didn't appropriately take that out while you were retired, and both you and your spouse passed away. That's $500,000 that's landing on your final tax bill. And I can assure you that CRA likes to take a good chunk of it because of our tiered tax structure that we have in Manitoba. So, again, those strategies are really important. A further piece on that, when we talk about our cottages, in Manitoba, we like our cottages. A lot of us have our secondary home on Lake Winnipeg or in Kenora or in the Lake of the Woods. And the reality is that these are secondary properties. And so if you pass away, and this is going to go to your children, there is a deemed disposition in the year of passing, whether your children choose to sell it or not. They're going to look at what the market value is at the time of passing and what your adjusted cost base is. And adjusted cost base is different than purchase price. Adjusted cost base is going to be your purchase plus improvements, reasonable improvements over time. But there can be a pretty significant difference between what you purchased it for and what the deemed disposition is at passing. And if we don't plan for that, there can be a significant tax liability. That means that if the beneficiaries don't have the capacity to pay for that, they may inadvertently have to sell the family cottage that they didn't want and you didn't want to cover that tax bill. So again, having those conversations is very important. And things like insurance become a conversational piece as well to make sure if there are those gaps that we can cover it and leave those funds where you want them to be. Okay. So let's talk a little bit about, we've talked about some of the common pitfalls. Let's talk about the process. How do we establish an estate plan? And there is a lot of legwork. This is not an easy process. And a lot of the time people stop right here when I tell them, here's the things that we need to do, and they get incredibly overwhelmed. But it is in your best interest to persevere through that component and start making this a priority. So the first step that we want to do is we want to start gathering all of our information. And so when we talk about gathering information, this is understanding where are your assets? What are your assets? We're almost doing a balance sheet for your personal situation. Do you have assets at Bank of Montreal, TD, and the credit union? And if so, let's talk about that. How much do we have in each place? And what do we have in tax-free savings versus RSPs versus RIFs versus non-registered? Getting a compilation. Do we have that real property? Do we have houses? Do we have cottages? Do we have digital property that's important? And that can be even, your cloud where you have all your pictures and memories that you want going to your children. That's important as well. Do we have jewelry in the house, and where do we want to disperse that to? Recording all of that is critically important, and then recording all of our liabilities. So where is that as well? Understanding and collecting our tax documents. So getting our T1 generals, understanding what our taxable income is year over year so that we can start building out those estate strategies that are relevant for your personal tax situation. And then that's the data component. So it's great. We've got all this information, but the other component that's very important and is going to be very different for each and every one of you is, what are your goals and what matters most to you? Because the word legacy is very different for every single person. My legacy could be, my life goal is to spend every single penny before I die. And when I die, there is a 0 on my final tax return. And maybe you give a penny as a donation somewhere. Maybe that's my goal. But maybe my goal is to leave $1 million to my kids and help move forward the next generation. Or maybe I don't have children, but I have a scholarship fund that I want to set out, and I want to make an impact for something that matters most to me. And so understanding your goals and what your priorities are is critically important to setting up a wealth transfer strategy that makes sense for you. And after we've gathered all of that documents and we've started to define your goals, then Kendra comes in with, all right, let's talk about some of those legal documents that are critically important to make sure all of this comes together.
I think a lot of the things that you said are really important. Like you said, that legacy. When you think legacy, it sounds like a big, grand topic. But then you reminded me of a case where a guy didn't want to leave anything to his family and left all of it to some non-relevant charity to himself, and the family was very disappointed to find out they couldn't challenge it. It was a recent case about the last 6 months. So when you think about what you want, it all comes down to those documents. Now, I will also add, it doesn't matter where you start in this process. I have many clients who don't have a financial advisor who come to me, and we start, and then I say, gee, you probably should talk to a financial advisor and an accountant. And vice versa. So you can join into this process wherever and do as much. I would prefer you don't do as little, but do as much of all of the pieces that we've said. So the main documents that we are talking about would be your will and um, really good point about cottages, especially cottages in Kenora. Fun fact, Ontario has probate taxes, even though we don't. So if you have a cottage in Kenora, not only should you have one will, you should have two. You should have one just for your Ontario property so that only that is taxed, and one for your Manitoba property. The same can apply if you have property in other provinces or in another country. Um, and making sure that that estate plan reflects what it is that you want. And we talk a lot about those beneficiary designations and your registered accounts to make sure that they're set up the way they're supposed to. Almost every one of my clients, I have that discussion about that tax-free savings account, and is it a beneficiary or is it a successor? And it's on that to-do list for everyone to check. The other thing that isn't talked about as much, but I would argue is almost more important, is your power of attorney, because that is what happens when you're still alive. And I had to think about, if I didn't get back up from that accident, oh dear, the person who would have defaulted to managing my money is not someone I would trust. So I needed to create that, and I did immediately. So you don't need to be a senior or getting old or be sick to need to do these plans. The scary thing is, it's actually more dangerous to be driving on the road than it is to, do all kinds of other activities. And then there's the healthcare directive that is a piece. I'm not going to delve into that very much, but your healthcare directive are your medical wishes and what you want if you're unwell. Um, Commonly, the power of attorney is misreferred to in that sense. So if the paramedics show up and they ask for mom's power of attorney, that's not the document they need. Daneeka needs the power of attorney, whereas the doctors will need your healthcare directive. And so let's roll into some little more details with that. So Who do you pick to do these jobs? Well, and of course, the law loves to be nice and confusing with names and different terms. So, if you're doing your will, your executor is the person who manages your estate. If you die without a will, they call it an administrator, just to make things complicated. And you may also see the term trustee in there. Now, picking an executor is really important. If I leave one thought with you guys, it is being an executor is not an honor. It is a very difficult job, and you don't want to pick someone because you think they're going to be left out. I have a lot of clients say, I don't want any of my kids to be left out. I want to appoint all four of them. Quick example, picture Christmas dinner and you're there, and the adult kid takes the last of the biscuits, and then they start to fight. Take that biscuit away, put a house. Take you away, and then they're there to fight over it. Doing your executors in order, one after the other, and picking someone who can do the job. And it doesn't have to be your children. It could be a friend. It could be a professional. It could be like the banks offer trustee services as well. You never want to appoint someone in the US, and generally speaking, not in another country as well, because there can be unexpected tax and reporting burdens. With that. And that also is more important when you're talking about your power of attorney as well. I use my spouse as an example because he's a dual citizen. So as much as I try to tax plan in Canada, if anything happens to me or to him, the US gets brought into this. And so when you're picking your attorney, that can also become very important because if I'm incapacitated and he's my attorney, he has to report my assets to the US government. So be careful with that. And it is citizenship, not residency, that dictates those things. So keeping within the province is ideal. If you have to appoint an out-of-province executor or attorney, we need to put some legal things in there so that their job is easier. The other thing too with picking an attorney, which I don't think I clarified, that's the person who takes over under your power of attorney if you're unable to manage your finances or your legal matters, is you need to pick someone you trust. Client asked me, well, if I have $1,000 under my mattress, what is my attorney supposed to do with that money? Supposed to, they are supposed to take it, track it, invest it, and keep it, and probably put it in the bank. But is there anybody there when they lift the mattress up and find the $1,000? So there is safeguards in place, but you must trust them to follow them because sometimes it falls between the cracks. You also want to think about family dynamics. Most of the time, I sit there and I draw a family tree when I'm sitting down with a client. I'm trying to figure out who's important, who gets along, who doesn't. And if there is conflict, you want to set up a way to prevent that. And oftentimes that can be an impartial party. And so it's really important to look at the whole picture while we're estate planning to make sure that none of these issues pop up and that we have picked the right person who can do the job as opposed to someone who's going to be emotional and overwhelmed and not be able to sit down and do the work because it is very difficult to be in any of those roles.
I think too, something to acknowledge in this respect, and I don't like, and you've driven this home, but I want to push a little bit harder with that power of attorney because I have a lot of clients who say, "Well, my wife is on everything. Like we're joint with everything. She's on my bank account, she's on my investments." Okay, but here's the thing. She's not on your RIF and she's not on your tax-free savings account. And so if you are incapacitated and she reaches out to your advisor to take money out of your investments to support the household while you're in the hospital, she cannot. She
Yep.
cannot take money out of those registered investments because she's not the power of attorney. And to add a layer to that, let's say you're incapacitated and you're in the hospital and there is a tough life decision that needs to be made. The house needs to be sold. Well, you're joint on that house, sure,
Yeah.
but you're not the sole signer. And so
Yes.
both of you have to sign on that house. And so if your spouse is in the hospital and they can't lift a pen to sign and they don't have capacity to make that decision, you now need to go to the courts and be appointed as the trustee for
Yep.
your partner in order to sell the house. And every time an offer comes in, that needs to go back to the courts and be approved. And it can be extremely costly and extremely cumbersome. And it is extremely avoidable by you just going and seeing a lawyer like Kendra and getting a power of attorney document. And then when those tough decisions need to be made, you present those documents to the respective party that you need to action them on, and we can get it done.
I will add to that too, actually. The Homestead Act really complicates a lot of things. So it's not even about the spouse taking that over. So when we're doing a power of attorney, we always need an alternate if there is a family home. Because think of it this way, with me and my partner, if I'm incapacitated and he's my attorney, he cannot give himself permission to sell the house. So what happens is your alternate signs off on that homestead agreement. And I actually discovered one of my prior documents before I was really had my practice up and going. They missed that on mine. So you really want to make sure that you have a lawyer that keeps up with this, that knows these rules, because those inadvertent mistakes cannot be fixed once you're gone, once you are incapacitated. And sometimes decisions need to be made. And if you don't have the right vehicles in there, like my power of attorney documents are 10 pages long. And very little of that is edited. It's just all of the legal stuff that the professionals and land titles needs to get things done. Um, so that's a really excellent point for sure.
And a couple of other key points, because I come at it from an investment perspective. I have a lot of clients who will say, well, my power of attorney is in Montreal. I love my nephew. He's phenomenal. And so I want him to manage things. And I say, well, that's not actually helpful at all. You have family who's here in Manitoba. And so as an investment professional, if I have a power of attorney that is going to be enacted because my client is now incapacitated and you're in a different province, if I'm not licensed there, I can't help you. I need to be licensed where your feet are, and I need to be licensed where you reside. And so, I'm lucky enough to be licensed across a couple of provinces. And so sometimes that's okay, but a lot of advisors aren't. And so you can end up with a pitfall where your person is in a different province and all of a sudden your assets cannot be managed because your power of attorney is not. We can't act on it because we're not licensed where that power of attorney is. So be aware of that component. It's really important.
Yeah, and also too, if you're crossing provinces, validity is very different. When my grandfather was in the hospital, he was in Nova Scotia, and I ended up being the major person managing that because the family is very small. And I had to make it very clear if I brought the Nova Scotia one into the Manitoba branch, this is a Nova Scotia document. It would not be valid here otherwise, and it's for a Nova Scotia person. So it is best to appoint someone here. And I just remembered something else that I had written down to say as well about cross province. One of the other unintended effects of intestacy is that those who apply to be your administrator need to be a Manitoba resident. So this summer, my partner and I were going to Japan, and I have a will, and despite being married or engaged to a lawyer who does this, he didn't have one. And I said, like, before we were getting on this plane, if the plane goes down, to be blunt, there is no one else here in Manitoba. Our family is in Ontario, so no one could apply to take over his estate. It's fine if something were to happen to him and I'm still here. But we at midnight, right before our flight, did what we needed to do to put a plan in place just in case.
Yeah, 100%. And now I'm cognizant it's 7:40 and I want to leave time for questions. And I have so many stories that I want to share with you guys. I have so many lessons and like takeaways, but I'm going to run out. And so let's talk a little bit about next steps for you. And so, of course, I work for TD Wealth, but this is doable across any platform. Connect with a financial planner, somebody who has a designation, a CFP. Connect with a lawyer, connect with your accountant, and start having a conversation. The people that you bring into this component to talk to with you, it should be a collaborative approach. They should be willing to get on a Zoom meeting and have your people having a conversation together instead of you playing, what's that, where you go and you speak through a can and it goes to the next per telephone. And then all of a sudden at the very end, the conversation is quite different than what it was at the beginning. You should be able to get everybody together and on the same page to articulate your wishes and set the right plans in motion. Most financial planning firms will use planning software and be able to create a document for you that can address these pieces with written strategies and considerations and an estate planning overview. And that's important so that you understand. But you can take this document and you can put that with your will and you can put that with your power of attorney so that when your people need to action it, they've got a list of what was intended and what was hoped for, and they can go off of what your wishes were. So next steps are connect with your people to have this conversation and start curating a plan that's right for you. Okay, schedule a review, get that comprehensive support in there so that you're protecting your loved ones, you're protecting your future, and we've got the right pieces in place. Now, I recognize, Tracy, I didn't leave a whole heck of a lot of time for you. I clearly wasn't managing my time appropriately, but I'm going to jump over and pass it over to Tracy to talk a bit about the power of planned gifts. And I recognize that if we go over 8 and you guys have questions, we will stay to answer them. So just wanted to give that over. Tracy, we're passing the torch.
Thank you. I was just going to say, it was interesting, Kendra, when you talked about jumping on a plane. Before you jumped on a plane, you had to get your will done. My husband and I did that very thing because we have 2 boys, and we've never traveled just the 2 of us together. And we wanted to and we did that before we went to Mexico last year to celebrate a milestone birthday. And we we made sure we had that will in place, so in case something were to happen to us, our boys would be well taken care of. So it does happen a lot. And so I'm glad that you mentioned that. So, but anyways, thank you for that. That was really interesting and fascinating. Thank you for all of that. I just want to do a very cursory overview of the power of a plan gift. So if you want to just go to the next slide, Chris, and just say, as part of your estate planning, and personally, my husband and I have done this, where we've just recently done our wills, as I've said, and we've created a legacy gift. We have chosen the University of Manitoba. We have a student award at the University of Manitoba, and we've put in our will that a portion of our estate will go towards that student award in light of our passing. And so we've done that because the University of Manitoba is very important to us, and we were both former Bison athletes, and that's the award that we have. But a number of people do this with whatever organization or organizations that are important to them based on a number of different reasons. And so, besides that, the thing that's important to you, it also can help. The other things is there's tax benefits to you and your family by leaving a legacy gift. You are giving back to the community. And in the case of the University of Manitoba, it's creating a legacy at the University of Manitoba. Chris, if you can move to the next slide. And so a planned gift is just that. It's an expression of your values, and it's an example to share for future generations. And it's really also what we have found, it's embedding philanthropy in sort of what we do as a family, and in showing with our boys as to what we'd like to do with a portion of our estate, that it's not just all going to them and family members, but also to another cause that will impact student life. Next slide, Chris. Now, there are a number of different ways. If the University of Manitoba was of interest to you, there are student awards, like I've shared with my personal experience, but there's many different ways to support the University of Manitoba or another organization in that case. So at the U of M, you could also support a program. A lot of people like to support students. That's very important to them, whether it's through a scholarship or a bursary program. And it also, you could also help to enhance University of Manitoba facilities, buildings, and whatnot. Chris, next slide. And there's many different ways that you can you can incorporate a planned gift. And so I'm not going to go through them all. Some of them are easier to understand than others. I actually had to look up what a trust was. But I'm sure Kendra and Daneeka are well informed with that. But a trust, as I understand it, is an approach that you can take to estate planning that could potentially avoid probate and reducing estate taxes. But I think what we're hearing tonight in our discussion is that it's really important to visit a financial planner and an estate lawyer to help you with all of this, to find out what makes sense for you, whether you do have property and what the size of your estate is. So, but there's many different ways, and we at the University of Manitoba do receive planned gifts. Many we know of, some we don't. And there's a number of ways that people decide to give a portion of their estate to the University of Manitoba. Here are just a few of those ways. Chris, next slide. And so, as I said, just speaking with a financial advisor is very important. And we have a plan giving team who also can help you with some of those. They don't have the legal background for sure, but they definitely can answer some questions. And so my wonderful colleague Charlene Knights is the director of our gift planning and lifetime giving program. And if you were to have any questions on this that I can't answer, she's the best person to connect with. So her information is here. It's also on our website if you have any interest in looking at that in your estate planning. So I'll leave it there.
Awesome. Do we have questions that have popped up? Can you see them at all?
No, not so far. I don't have anything in the Q&A yet.
So while we wait for a question, I'll throw out something to tie in the charitable aspect as well, and the power of attorney we were talking about earlier. One of the things that I've talked to with a few different financial planners is if you regularly give charitable gifts as part of your tax plan and you do not have it properly outlined in your power of attorney, your hands are completely tied. Your financial planner cannot assist you in doing further gifts without an explicit clause. And in fact, we've even, between a couple different financial planners, we've seen that some organizations need very, very explicit details if you want to be able to donate funds if someone's incapacitated. So if it is a very large estate and you're trying to offset taxes, you can't unless you have that document in place.
Yeah. I think I see one question that came in. Please expand on beneficiary versus successor. Thank you, John, so much for asking. I know that you knew that I wanted to talk about this. Okay, so let's talk TFSA primarily. Successor versus beneficiary. This is the big one. So if you have a beneficiary. And I'm going to first talk about beneficiary designation on an account explicitly, and then I'm going to talk about beneficiary designation inside a will, because that's also different. But if you've got a beneficiary on your TFSA, and I'm going to relay this primarily to a spouse, because this is the only time that it matters. If you've got a beneficiary and you put your beneficiary as your spouse on your TFSA, and you pass away, and let's assume that you've got $100,000 in your TFSA, and from the time that you pass away till the time that everything is settled, that TFSA grows to $105,000. As a beneficiary, the $100,000 in that TFSA will flow to your surviving spouse's TFSA and not impact their TFSA contribution room. So that'll flow over. But the $5,000 in growth that happened from the time that you passed till the time that we were able to action this, that is not tax-free, and it is going to be taxable to you. And so that is going to eat up your spouse's or your surviving spouse's TFSA room. And if they don't have any, guess what? It's coming out and it's going into their bank accounts. Whereas if it is a successor, life is so much easier. We just take that TFSA and we move it right over into your spouse's name, and it continues to grow tax-free, and there is no implications about when we make that transition over. So TFSA, critically important that you have a successor, not a beneficiary, if it's your spouse. Now, if you have opted not to have a beneficiary structure set up on your account itself, but you've designated your spouse as a clause as the beneficiary in your will, there's a simple form that most people don't know about called an RC 240. I believe. And so ultimately, as a financial institution, we can acknowledge the beneficiary structure in the will, and we can move that TFSA asset at passing over to your spouse without any taxation. But there's an RC 240 that needs to be filled out to acknowledge this with CRA. And a lot of the time that form gets missed. And so all of a sudden, a couple years later, because CRA isn't fast on anything, it typically takes them at least 2 years, they're going to come back and say, whoa, 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 you over contributed to your TFSA by $70,000. You owe us. You owe us 1% per month for the last 2 years. And you have to fill out that RC 240. I think it's within like 30 days of the transition. And so it can be a fight. So successor versus beneficiary, very important when you have a spouse. Now I'm seeing some more.
Yes, we have 4 questions that have come through. So the first one is, how is the best way to gift certain personal items to individual family members?
Kendra, I'm going to leave that one with you.
I can handle that one. There are many different ways to do it. So first off, it depends on whether you want it to be legally binding or not. So if you need it to be legally binding, it needs to go in the will in one way or another. If you're looking at just, I want all my stuff in my house to go to my spouse, for example, that's a very simple one. If you picture grandma who has all her trinkets with all the sticky notes on the bottom of everything, I'm not a fan of that because sticky notes can fall off. If you trust your family to get along, you can make a list, have some pictures, do something that is informal. But if you need it to be formal, you can either write a memoranda that is attached to the will, and that needs to be signed and executed the same way a will does, or you can list them specifically. So a great example is I have some very beautiful homemade quilts from my grandmother, and if I die before any other women in my family, they will kill each other to fight over grandma's quilts or great grandma's quilts. So I've actually listed who gets what because I know that's a fighting point. Now, the other thing too is if you don't think your family will get along, I had a great client who had 2 matching guitars and each kid was getting a guitar and she knew they both wanted one. And she said, they look the same. They can flip a coin and I'm going to go to my grave knowing which one is the one they were both going to fight over. So you can put tiebreakers or drawing lots or things like that with that.
Okay, thank you, Kendra. Okay, the next question is to me, but I do feel that I need Kendra's and Daneeka's help on this because I'm not a financial whiz here. But the question is, Tracy, are you saying that if I want to give some of my RSP funds to the University of Manitoba, do I have to pay the government my 50% taxes, but I'm still alive? It's a really great question.
Daneeka, that's a tax one. You can have that one.
Can you answer that for me, Daneeka?
So there's a couple of layers in here, and I'm going to speak to charitable donations because that's what you're doing when you give to U of M. Right. It's a charitable donation that you're going to write off against your income. And so when you're living, you can write off up to 75% of your income. And there's a couple of new rules that came in recently. So you would be able to take some money out of your RSP if it felt right to you, if it wasn't going to have any financial implications from a longevity perspective and supporting yourself. So let's say, for example, we wanted to gift over some money, we could take that out. You are going to declare that as income on your income tax. And so it may or may not be valuable to you. And then we're going to donate that over to U of M. They're going to give you a charitable donation and you're going to write that off against your income. So you're going to get an offset, but it's not going to be an 100% offset. The difference when you pass is when you pass, anything you've donated 100% can be offset to your income in the year of your passing. So there is a different benefit. Generally, when we look at donation strategies while you're living, most of the time we're looking at non-registered assets. And so a lot of the time we'll look at gifting strategies where we cut a check. Let's say I've got one client where we know it's all going to go to the Winnipeg Foundation when she passes, but we might as well split that burden, that tax burden over time. And so we cut a check for $35,000 every year to the Winnipeg Foundation. It goes where she wants it to go. She gets to be part of those scholarship foundations. She donates to St. John's High School, which is pretty great. And then she gets a tax refund on an annual basis on there. So Yes, you're going to pay your taxes if you take it out of your RSP. There is going to be a donation offset, but it's not going to be entirely. So we need to look at the broad picture there.
Okay, thanks for explaining that, Daneeka. That's great. Okay, the next question. How complicated is leaving a U.S. property to your adult children?
Kendra?
I'll take that one. You're not going to like my answer. It depends, but I will elaborate. So, if you have US property, you really do need to speak not only to a US attorney, but someone in that state, because every state has very different laws, and the way they would interact with Manitoba law will be different. So, oftentimes, when I'm dealing with a snowbird who has a US property, Florida is a great example because I actually have a buddy who practices law in Florida. We will coordinate the two documents together. So they will prepare a Florida will, I will prepare a Manitoba one. We will make sure that the execution of those happens properly. So if you decide to do that on your own and have multiple wills, the key is to make sure that you do not automatically revoke the prior one. So I really encourage you to consult lawyers in both locations before you bring that plan forward, because every will I do, the first line is I revoke any prior wills. So if you just signed the Florida one, you automatically revoke it 5 minutes later if it's not changed properly. But yeah, anytime you have out of province or country property, you want to make sure that you're very well aware of that other country's estate laws and what might apply with that as well.
Yeah, and I think the big piece is potentially having those dual wills to recognize in those different locations, right? And people
Yeah.
don't think about that. A lot of the time we write a will here in Manitoba and we're like, well, it's going to cover all of our property everywhere. And you're like, actually, it might not be acknowledged where you want it to be, and it might not be worded appropriately. We need to make sure that it's covered in the location that your property is located.
Yeah, and multiple wills is not a thing that Manitoba is as up forward with. Ontario is very big on that. And that corporation example you gave before as well, a corporation is a separate entity. They can have a will as well. So sometimes we bring it in not just for out of province, but for those different things. I have three, my new ones I'm working on, I will have three. One for my Ontario law practice, one for my Manitoba law practice, and one for my personal assets, because they all require different handling. So,
Okay, thank you for that. Okay, our next question, term life insurance. It is expensive. I would concur. What are the other ways to pay for CRA taxes at time of passing?
Daneeka.
Yeah. Okay, so there's not much we can do at time of passing if we haven't planned for it in advance. So ultimately, you're going to have the life insurance if you don't want it coming out of your pocket, and if you are comfortable with that, then when we think about this from a perspective of your RIF, if you've got a beneficiary bypasses your estate, but your estate still needs to pay the taxes on that RIF. Right. So if you have 300,000 in your RIF and you've got a beneficiary to Kendra's getting the 300,000, but your estate has a tax liability for that component. And how are we paying for that? That's a very good question if you've got nothing else. So you've got maybe your RIF and your TFSA that have beneficiaries that may not be able to cover off the estate tax. You have non-registered investments or bank account balances. You're going to have real property, maybe your home, maybe your cottage. And so if we haven't tactfully planned for this, and the only things that fall into your estate are your house, your bank account, and maybe your cottage, maybe you don't want your cottage and your house sold because you want it going to your children, and the only thing that's left is your bank account balance, and this RIF over here has like $100,000 in taxes outstanding on it. Now your executor needs to make some calls. They can either cover those payments so that if they're the beneficiary too, they can retain the property, or they have to make that decision to sell that property to cover it. The biggest way for us to mitigate those CRA taxes at passing is pre-planning. So looking at creating a financial plan 10 years in advance. Now, the crummy thing is we don't know when we're going to pass. If we did, life wouldn't be nearly as adventurous as it is right now. And so we can gauge, we can make some assumptions, but we need to look at it over your lifespan. And so when I look at a plan with a client, if I have, you know, $150,000 outstanding in a RIF or a projected RIF at 75, I'm not really concerned. But if I have 300 or 350,000 in a RIF or an RSP when you're 75, I'm a little bit concerned. This is where we start looking at, do we take money out every single year? Keep you within a healthy tax bracket, but shuffle that money over to a tax-free savings account or a non-registered investment. We're realizing the taxes today at your lower tax brackets and then not having a sizable estate tax burden. It's about pre-planning post-pass, like pre-planning before you pass. It's how we can avoid those CRA taxes. Don't leave it until your deathbed.
Yeah,
I will
definitely.
give you one very good example where we attempted to mitigate it and we didn't. So, you know, I met a client and they had congestive heart failure, and ultimately they had a sizable estate. So they had about $500,000 in registered investments that were going to become taxable upon passing. And I met them when they were already in a pretty difficult diagnosis. And it was a difficult conversation. It was essentially, we're wagering on your life. If you live till January 2nd of next year, I can take out X amount of dollars out of your RIF this year and keep you at a 30% tax bracket. Pay a little bit higher today. We're going to have some old age security tax clawbacks. But then if you survive and you make it till next year, we just cut your tax bill in half because the rest is going to fall in next calendar year.
Yeah.
But if you pass away December 31st, all of this was for naught. It's all going to fall on your current tax bill. Don't be that person. Don't be that person that we're wagering that you're going to survive till January 1st. Be the person who has planned this 10 years in advance, who's planned this throughout your retirement, that we've got solid strategies in place to support you.
Okay, great. Good advice. Okay. The last question I have, if anybody has any more questions, please do feel free to put them in the Q&A or the chat. Okay, so I may not be pronouncing this right, but the question is, could you explain the role of codicils? Is that
Yep,
what they're called?
codicil. That'll be
Codicils.
me. So way back when all we had was typewriters, you had to type everything out. And so it wasn't efficient to redo a will if you were just making one or two tiny changes. So the codicil was a tool for that. Nowadays, it can be used, but you see it used less often. So one thing I always let people know in my own practice, I won't do a codicil or an amendment to a will that I didn't draft because they become one and the same, and I'd be liable for the stuff that's in the document that I didn't write. That being said, if I have an existing client, we will often just reprint the will and make that change in there rather than doing a codicil. I have seen in some courses when capacity is an issue. So if someone has early onset dementia, Alzheimer's, something like that, we may use a codicil so that the original will doesn't get challenged and that it would only be that change, but that's a very rare circumstance. So when we're looking at planning, it's just neater nowadays to hit print with a fresh copy instead of that full codicil.
So I guess in summary, a codicil is almost like an amendment that we shove in to
Pretty
change
much.
something. Yeah.
Yeah.
Sorry, there we go. Somebody just joined late. Okay.
Oh,
What is the average cost of a will? $400?
no. That is the cost for a power of attorney. I'm going to start with saying that every lawyer prices their services very different. So if you want someone who is going to take that time and be detailed, you're going to pay more. I myself work from home and go to clients' houses, so that brings a slightly different aspect to things. You're going to probably pay in total for your will, your power of attorney, and your healthcare directive anywhere between I have some like low income senior clients who have very little property. They usually fall in the 600 to 900 range. Homeowners yearly looking anywhere from 1,000 to 2,000. For me, if I'm doing a couple, I discount that second one. And it really depends on the complexity of your estate. Someone comes to me and says, "Oh, my will is so simple." And then after an hour and a half meeting, I've realized, oh, we've got 3 pages of this we have to type, we have to customize this. And of course, if you're bringing in a different province and another will, so if you have a cottage in Ontario, we have to do a second set of will. So it really does depend, and you need to be comfortable with the lawyer you're hiring. So if you're going somewhere and you're not sure what their prices mean, ask. Because if you ask me what my prices are, I can lay it out and show you exactly, this will is going to take me 10 to 20 hours to do. If the lawyer can't defend their prices, then do seek out someone you're comfortable with.
Yeah, it's one of those hard things, right? Like, I've been talking to my clients about having a will and a power of attorney in place for years, and I could preach it, but I didn't have one because I couldn't justify the cost, and I knew how expensive it was going to be. I had a lot of complexity, and so to go in and actually write it, there was two things that were holding me back. One, the complexity. I knew I was going to pay it like an arm and a leg for this document, and I just didn't want to do it because, like, man, I'm not going to benefit from it, but my family sure is.
Yeah.
My kids are if I die, right? And then the second piece that really stopped me was, who's my people? Because like my sister's going to think that she's my executor, but that's not the person that I need to manage my finances once I pass. And then who's managing my children? Because I have two young boys, and that's somebody completely different because their values align with how I raise my children. So there was some big pieces in there that I felt that my family was going to take offense to if they knew it. And so it took me some time to write those documents. But it's so critically important that we pay. Like we just do it, like get it done. And a lot of people are going to say, well, I could just do a will kit. Or,
Oh dear.
I could do in Manitoba a holographic will. Like that's accepted. It's accepted, sure, but is there going to be holes in it? Probably. And if somebody contested it or didn't agree with it, oh man, you're setting yourself up for a position that maybe you didn't intend in at the end, right? So, it sucks. I don't want to pay Kendra. I like her though, so I'm going to do it, but more importantly, I like my family.
Yep.
So,
And it really is about protecting those loved ones. I say it is the most selfless thing you will ever do because it's when you're gone. But thinking as well too, like you said about your people, there are rules in place for what happens as those defaults. Another one people don't realize is when someone's acting as an attorney, they need to report to someone, and that reporting is to the next nearest relative. Well, if you have an abusive family member or an estranged family member and you don't want them being served with your business and your numbers and your accounts, we need to put that in the document. And that's a conversation I often have with young people is it those defaults that you would want? Because if not, we need to protect you. And we need to make sure that your wealth, your assets are protected from those that you don't want getting into them. And maybe there's someone better who's going to manage it.
mm-hmm.
Okay, we have a question and a comment. We have a lovely comment from Tom who said that both of you did a wonderful job on the presentation. So thank you, Kendra and Daneeka.
Thank you, Tom.
And our last question is from Joan, and it is, we have a daughter living in the US. What are the issues in passing her share of our estate to be?
Want me to handle that one? So when you're passing things on and you're not appointing them in those key roles like attorney or executor, it's not that challenging to do. It's just a bequest. What you would want to do is speak to someone in that state to just make sure there's no unnecessary tax implications on them receiving that gift. Because of course we can't give that advice from this end. But if it is just a straight gift, it is pretty straightforward. You would just do it the same way you would do for anyone else. It's when you put them in those roles where they will be managing things where it becomes significantly complicated.
Yeah, and a lot of the time, like if we've got a beneficiary in the US, and let's say, for example, for some reason they can't make it to Canada, because in the estate settlement, we generally need a letter of direction from each beneficiary to dictate where this money goes. So when you're settling your estate, you can do it two ways. So the first one is You connect with the financial institutions, you've got your will, you got the will probated. So that was the lawyer, they did it. You bring the probated will to the bank opens up an estate account. Maybe we take all of the money and we funnel it there. Maybe we don't. Maybe we want some of those investments to stay as investments and we take a letter of direction and move those shares or those ETFs in kind to the beneficiaries. That's a potential. So there, we're keeping some of the assets whole potentially, and we're going to disperse it out. And so then all of a sudden, the bank is helping you or your executor settle this. And if there's a beneficiary in the United States who can't come to Canada, we rely on a notary in the United States. So they're going to have to seek a lawyer out there to validate their identity, to witness those signatures. And then we're going to send those documents up to Canada and then process them through here. So like Kendra said, it's not excruciatingly challenging. There's just some extra steps when the beneficiary is in the United States. The second way that you can settle an estate is where you take and you say, hey, Kendra, and maybe this isn't Kendra, but like, hey, lawyer, I want my lawyer to manage it. And so all of a sudden the lawyer who is dealing with the probate is going to all the financial institutions and saying, hey, forward me this money to my trust account. And so then all of a sudden, all of the money sits with the lawyer, and then the lawyer cuts the checks and disperses them to the respective beneficiary. So there's two different ways that we can navigate an estate settlement, and it just depends on who's navigating it and what's going to be right for them and the family.
Another question has just come through. Are you okay to answer it?
Yep.
Okay. What are trusts about and who needs to use them?
Great. So I think Kendra and I can both talk on this one.
Yeah, you go first and I'll fill in the blanks.
So there is a lot of different reasons that we use a trust structure. It can be from a perspective of those individuals with a disability. Ultimately, a trust is a separate entity. So here's your beneficiaries over here who are people, and then here's a trust, and it's almost like a corporate structure that keeps money separate and away from your beneficiaries. So some situations where this is beneficial is if we're concerned about, marital disputes. Maybe your son has a really lovely wife that you don't think is so lovely and you want to make sure she doesn't get your money. You might set up a trust structure. It has to be discretionary trust, and then you can flow it through so your beneficiaries or your children and it flows out. There can be some tax mitigation strategies potentially where we use a trust structure. And so then again, we have a choice. Do we tax inside the trust, or do we flow those assets or this tax bit, like the interest earnings and capital gains over to the beneficiaries on an annual basis? But there's some cautionary tales in there too. Attribution rules apply if you're living versus if you're not living. There's certain circumstances. Sometimes when we want privacy of assets, so we don't want it probated. We don't want, a probate is a legal document that goes to the Court of King's Bench where anybody has access to that information and can understand what the size of your estate was. And if we want some discretion, we can have a trust, and that trust potentially doesn't probate those assets if it's like a trust established pre-passing. So there's different reasons that we're going to use a trust. And if you're interested in it or you've heard about it and you think it might be the right thing for you, before you decide to go down that path, talk to your lawyer, talk to your advisor, because it also is costly. It's costly to set up a trust. It's costly to manage a trust on an annual basis. There's additional tax filing that we have to do. And so there's value in it, but under the right circumstance. Kendra, do you want to add in there?
I think the big thing that I always say when we're talking about a trust is it is any type of conditional gift. And of course, I'm only talking about trust in your will. My specialty is the trusts that happen after you die rather than the ones that come in first. But it is as simple as I want to give something to so and so, but the second you say but, we're creating a trust. But I don't like his wife, but he is underage, but she is a little spendthrift and we need to be careful. Anytime you say that, we create some form of trust because it's a conditional gift. and they can be used for so many things, but sometimes it's not worth it. I had one where there were multiple gifts where we were protecting from spouses and if there was divorce, and the trusts alone, I think were 5 pages. So that $2,000 will is no, like, you're now creeping way above that if that has to be custom drafted and fixed for that. So you do really have to weigh the benefits, like Daneeka said.
Yeah. Oh, another one. So trust. I had a really good one recently. So lovely family. They've been married for years, 50 years married. Like so great. They've built an empire together. Like they're proud. The wife desperately wants a spousal trust. Why? Why? She says, well, because if I die, I don't want him to get married again. And all of the assets we accumulated go to the next wife and not go to my children. They need to go to my children and my grandchildren. And so, there was a big heated debate around it on like, is this a necessary, reasonable, appropriate structure for you? You've been married for 50 years. He's like, I'm not getting married again, but she's really worried that he would. Who knows who's going to die first, right? But we can create complexities in situations where you've established a lot of wealth and you don't want those next rules to come in place, where you don't want a second spouse coming in and having those matrimonial rights there. Spousal trusts can also be a factor. So it's that but clause that Kendra mentioned, but there's certainly aspects where they make sense.
Definitely.
Can you tell that we really like these conversations?
Yes.
Like,
Yeah, that was fast. That was fascinating. Thank you very much. I think we're going to end it there, everybody. But I just wanted to say thank you, Kendra and Daneeka. I'm sure we all learned a lot more than we knew going into this. Thank you for sharing your expertise, just being candid and honest with us. Thank you to the UM's affinity partner, TD Insurance, for your generous sponsorship of this webinar series. Thank you to all of you for coming this evening and for all your questions. It was a really wonderful conversation. So I just wanted to also put the plug in. We've got a few more Tuesdays with TD sessions that are coming up in the new year. Sorry, we don't have any more before the holidays, but our next one is on January 27th. And that one's on Everyone Needs a Budget, Key Budgeting Tips. February 24th is on home ownership and if it's right for you and your financial situation. And on March the 24th, it's on starting and growing your home business. So if any of those topics sound of interest to you, or others who could benefit from the advice, Daneeka will be leading all of those. Please do register. Keep reading your Have You Heard alumni e-newsletters. Look on social, look on our website. You'll find lots of information there on how to register. And also, as I mentioned earlier, we've recorded today's session. And so in our thank you email, we will make sure to send you a link to the recording so you can watch this again or share with others. So thank you for joining us, everyone. Enjoy the rest of your evening and go Jays go.
thanks, guys.
Good night, everybody.
Thank you.